one. Welcome, everyone. My name is Imran Ahmad. I'm a partner here at Norton Rose Fulbright Canada, and I'm delighted to be here with my colleague, Jeremie Wyatt. Jeremie's based in our Quebec City office and a member of our technology group as well as our privacy team. And today what we're going to do is we're going to spend a little bit of time with Jeremie and hopefully in less than 3 to 4 minutes, give you an overview of recent developments in the province of Quebec with Law 25 and some of the recent guidelines that the Commission à l'accès à l'information has issued. So we'll jump right into it. And Jeremie, can you just set the stage a little bit and explain a bit of the context around the Commission à l'accès à l'information's new power to impose monetary administrative penalties or AMPs?
Yeah, of course, Imran. Happy to be here. So Bill 64, which became known as Law 25 after its adoption, was adopted in September 2021 by the Quebec National Assembly the goal was to significantly overhaul and modernize Quebec's personal information protection legal regime. And one of the changes introduced by Law 25 to the Private Sector Privacy Act was the addition of monetary administrative penalties in cases of non-compliance with legal obligations. And we're talking very severe monetary penalties, much more aligned with what we can see under Europe's GDPR. So the monetary penalties can go up to a sum of $10 million or 2% of the company's worldwide turnover for the previous year, if higher. The Law 25 also covers the possibility of penal fines, which those can go up to 25 million or 4% of the worldwide turnover, but those aren't really discussed in this new framework that's been presented. And this framework was actually presented by the Commission d'accès à l'information recently, due in part to the fact that in September 23, the majority of the new provisions under Law 25 will come into force. So it's part of the CAI's power and goal to kind of introduce these guidelines.
Right. And can you talk a little bit about more what the CAI's application framework looks like? What does it cover exactly?
Yeah, of course. So the objectives, quickly speaking, of the framework are in three-part. Main objective is obviously to provide guidelines and criteria for what will actually be considered when issuing these penalties. Also to promote fairness and uniformity and make sure all these penalties are issued in the same consistent manner. And of course, to provide companies with a bit of an overview of what's considered by the CAI. It's important to note that the CAI's power to issue monetary penalties is discretionary. And to do so, they will consider a number of objective criteria, such as the nature of the breach, repetitive nature or duration, the sensitivity of personal information concern, number of people affected, etc. And the framework also outlines the specific mechanics for issuing a sanction. So first, a notice of non-compliance would be sent to the company by the CAI, notifying it that they're considering issuing a monetary penalty. This will give the company time to kind of make its observations and present its case. And if at the end of that process, the CAI isn't satisfied with what it was told, then it will issue a notice of claim imposing a penalty.
So you alluded to this a bit earlier, the penalty amounts, $10 million or 2% of global turnover. Can you speak a little bit about how these amounts are exactly calculated or determined by the CAI?
Yeah, of course. So the CAI has split its penalties into 4 different categories depending on the severity of the non-compliance that it noticed, ranging from low severity to very high severity. And it's assigned a base amount of a fine to each of those categories, ranging from $1,000 to $15,000. On top of that, following that sort of initial categorization into buckets, then the CAI will start playing with aggravating or mitigating factors, which will influence the amount of the sanction. So these can include the repetitive nature, if any forewarning was given to the business, if it's a repetition or anything like that. So those will ultimately have an incident on the value of the fine. And I think it's in very extreme cases where we'll see that it can reach up to that $10 million or 2% threshold that we've discussed. It'll be really interesting to see how this plays out, see what kind of trends come out of the CAI's application, whether 10 million is, the extreme cases, what will be more the average or the baseline that they use. So those are all interesting trends to look out for in the future.
Yeah, no, absolutely. I think everybody's going to be watching with a lot of interest. Look, that's all the time we have today. There's a lot of content that we went over, so thank you for that, Jeremy, for summarizing it so effectively. I remind our audience that we will be sharing more capsules like these ones with developments and tracking what's happening, in particular in the province of Quebec, but certainly across the country and globally as well. That may be of interest to our audience. So thank you again, Jeremy, and we'll be back soon.
Thanks, Imran.